4ST. Mr. Hartel, have you had adequate opportunity to discuss issues with your client? And Ms. Lawrence is on this one?
She
Or
is, I
Mr.
believe she's
Carnes?
turning in our offer sheet present.
All right, we'll wait for her to get back in courtroom. Is there a resolution as far as you know?
Yes, Your Honor, we would be accepting her offer of the civil infraction of impeding traffic.
All right,
Your Honor, I did discuss that with her, and that is.
all right. Mr. Monroe, have you heard what the attorney just said the resolution in this case is?
Yes, I am.
And is that how you wish to resolve it?
Yes.
It's my understanding that you'll be pleading guilty to the civil infraction of responsible to the civil infraction of impeding traffic. In exchange for that, the people will dismiss the 90-day misdemeanor of operating with no license or multiple licenses. Is that your full understanding of the plea agreement? Additionally, the civil infraction comes with a $100 fine. Other than the plea agreement, has anybody promised you anything in order to get you to plea today?
No.
Has anybody threatened you anything? And is it your own free choice to plea today?
Yes.
Are counsel aware of any of their promises, threats, or inducements not made part of the record?
No, Your Honor.
No, Your Honor.
All right, then Mr. Monroe, to the allegation that on or about June 15th, 2025 in Herring Township, Wexford County, to the added count of the civil infraction of impeding traffic, how do you plea, responsible or not responsible? The defendant having entered a responsible plea to the civil infraction, the court hereby imposes a $100 fine. And pursuant to the plea agreement, the charged offense in count number 1 will be dismissed. You can go out to the front window where you checked in and make arrangements for payment. All right, thank you. Court next calls the people of the state of Michigan versus Robert V. Kidd, case number 252852 SM. Francis counsel.
Courtney Lawrence on behalf of the people.
Robert Hartel for Mr. Kidd, who joins me at the table.
And you all may be seated. Today, we're here for a final pretrial conference. Is there any resolution in this case?
There is, Your Honor. It's my understanding that the defendant will be guilty to less than 200, and the people will dismiss count 1, larceny 200 or more, but less than 1,000.
Mr. Hartel.
This is accurate, Your Honor.
Mr. Kidd, have you heard what the attorney just said the resolution in this case is? Is that how you wish to resolve it?
Yes.
Please raise your right hand. Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Sir, it's my understanding that you will be pleading guilty to larceny less than $200, which is a 93-day misdemeanor and or a fine of $500 or 3 times the value of the property taken if the prosecutor can meet certain requirements. In exchange for that, the people will be dismissing count number 1 of larceny $200 or more, but less than $1,000. That is a 1-year misdemeanor and or a fine of $2,000. Is that your full understanding of the plea agreement?
Yes.
Back on June 24th of this year, were you on probation or parole?
No.
Were you on bond? Do you recall reading and signing this advice of rights form, talk about your rights to an attorney and your rights to a trial?
Yes.
Did you understand those rights? Most importantly, do you understand that by entering a guilty plea today, you'll be giving up the right to have a trial and you won't have a trial of any kind? Other than the plea agreement today, has anybody promised you anything? Has anybody threatened you in any way? It is your own free choice to plea today? Mr. Kidd, I need you to speak up. I'm having a hard time hearing you. And are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
No, Your Honor.
And Mr. Kidd, to the allegation that on or about June 24th, 2025 in Manton in Wexford County that you committed the offense and added count 2 of larceny less than $200, how do you plead?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on June 24th of this year, were you in Manton?
Yes, that works.
And would you agree with me that that is in Wexford County?
Yes,
And it looks like it's, you took a generator belonging to an Evan Parker.
yes,
And do you believe that that value, that the value of the item taken had a value of less than $200? Counsel, is there any restitution requested in this?
There is not.
Do counsel believe that the defendants provided a factual basis in which to accept the plea and the court rules have been complied with?
Yes, Your Honor.
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Mr. Kidd, I find you guilty of larceny less than $200 pursuant to the plea agreement. Larceny 200 to 1,000 will be dismissed. Are we able to sentence today?
Yes, Your Honor.
Is there any victim impact?
There is not, Your Honor.
Mr. Hartel?
Yes, Your Honor. I would ask the court to consider keeping this at a minimum fines and costs type situation for what it is worth. I don't recall any allegations of any bond violations during the course of this case. My client does have his wife for moral support. She's been consistently there for him throughout this entire time. I know he does have some disability, so he does appreciate her support and her assistance. If the court was on the fence between jail or probation, I do believe that the fact that he did good on bond is a sign he's supervisable. But I would also ask the court to factor in that he was honest with law enforcement. To my knowledge, all items were returned without any great negotiations required. He basically just turned them right over, him and his wife, if I recall correctly. I did watch the body cams. I didn't watch them earlier this morning, but I do recall them being honest with the police, returning the items. And I do believe that is worth factoring it in. It doesn't change the fact that he did something wrong, but there is something to be said about being honest once caught, trying to make the other side whole. And I ask the court to factor that in when fashioning a sentence. Thank you.
Thank you. Ms. Lawrence?
Thank you, Your Honor. The defendant and the victim, I believe, are neighbors in this case, and although the victim is not here to make a statement, I do know that he does have concerns that this may continue to happen in the future. Given that, I would ask for a period of probation. I would ask for that a no contact order to continue until the end of probation. I know that it has been some time, it looks like, in the defendant's criminal history since his most recent conviction, but it does look like he has several priors for behavior such as this. So I do think a term of probation would be appropriate. Thank you.
Thank you. Mr. Kidd, you have the right to address the court prior to sentencing. Is there anything you would like me to know?
no,
Well, Ms. Lawrence referenced the defendant's history, so I'll go through that. In 1983, there was a burglary. In 1989, a retail fraud second. In 2000, a receiving concealing 200 to 1,000. 01, receiving concealing 1,000 to 20,000. In 01, receiving and concealing firearms. In 12, receiving and concealing 1,000 to 20,000. In 09, baiting deer offense, and in 2019, an operating while intoxicated. Defendant was placed on bond on June 25th of this year, with the really the only condition that he not have any contact with the neighbor or the neighbor's property. And as Mr. Hartel points out, we have not had any bond violations. And all items were returned, Ms. Lawrence, is that correct?
Yes, Your Honor.
So, Mr. Kidd, I guess my question to you is, did you think you had a claim to this generator, or how does it wind up in your possession?
I thought it was just place was abandoned.
Place was abandoned and what?
I thought it was abandoned out there. There's nothing.
And but you know you didn't own it, correct?
Right.
And you're on disability, is that accurate? How much a month do you get? 900. Is that the only income you have? There will be a $75 crime victims' rights funds fee, $50 state minimum fee. Fine of $100. The court will waive court costs and will waive attorney fees. One-day jail with one-day credit. I am going to put the defendant on a period of probation for 12 months, given the defendant's past, even though it has been quite some time since he's had any theft-type crimes. Looks like the latest one was in 12. I think it's worth putting him on probation for some rehabilitative purposes, again, to remind him of what's appropriate behavior. During that time period, the defendant's not to violate any law, report is ordered, not leave the state of Michigan without the consent of his probation officer, keep contact and employment information current. You are eligible for early release. So at the 6-month mark, if you've done everything we've asked you to do, you can be released. If your probation officer doesn't think you should be, but you think you should be, you can you can file a motion with the court and we'll have a hearing regarding the matter. Additionally, I'm going to order that the defendant attend any programming that the probation officer feels that was accurate or appropriate, including retail fraud and theft and larceny classes, any counseling that she feels is appropriate. I'm only going to charge you for 6 months of probation. So that's $180. If something happens that you stay longer than that 6 months, you'll be required to pay the monthly probation fee. Now, Mr. Kidd, because I have sentenced you to a period of incarceration, even though it's time served, you do have the right to appeal that decision. If you decided that you wanted to appeal it and could not afford an attorney to assist you, you have 14 days from today's date in which to request an attorney. Additionally, any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that by operation of state law. You can go back out to the front window where you checked in, get a copy of your judgment, make a payment if you're able to. If not, get signed up on a payment plan, and then go downstairs to district court probation and get signed up for probation. Oh, I'm sorry, the no contact order will remain in place. Anything else, Ms. Lawrence?
No, Your Honor.
Mr. Hartzell?
No, thank you.
All right, thank you.
You're okay. No problem.
Court next calls the people of the state of Michigan versus Dylan Barron, case number 252899 SD. Appearances, counsel.
Courtney Lawrence on behalf of the people.
Robert Hartzell from Mr. Barron, who joins me at the table, Your Honor.
We are here for a final pretrial conference. Is there any resolution?
There is, Your Honor. It's my understanding the defendant will plead guilty to an added count of operating while visibly impaired. In turn, the people will dismiss count 1, operating while intoxicated.
Mr. Hartzell?
That is accurate, Your Honor.
Mr. Barron, have you heard what the attorneys have said the resolution in this case is?
Yes, I am.
And is that how you wish to resolve it?
Yes.
Will you please raise your right hand? Do you solemnly swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
It's my understanding that you will be pleading guilty to an added count of operating while visibly impaired, which is a 93-day misdemeanor and or a fine of $300. That means the court could put you in jail for up to 93 days. In exchange for that agreement or that plea, the people will dismiss count number 1 of operating while intoxicated, which is another 93-day misdemeanor, but has a fine of $100 to $500. You understand that? Back on June 29th of this year, were you on probation or parole?
No.
Were you on bond?
So,
Did you- Okay, you didn't have any other cases pending? Do you recall reading and signing this advice of rights form, talk about your rights to a trial, your rights to an attorney? Did you understand those rights? Most importantly, do you understand that by entering a guilty plea today, you'll be giving up the right to have a trial and you won't have a trial of any kind?
Yes.
Other than the plea agreement, has anybody promised you anything in order to get you to plea today? Has anybody threatened you? And is it your own free choice to plead today?
Yes.
Are counsel aware of any other promises, threats, and inducements not made part of the record?
No, Your Honor.
No, Your Honor.
Mr. Barron, to the added count that on or about June 29th, 2025, in the city of Cadillac in Wexford County, that you did operate a motor vehicle while visibly impaired, how do you plead? In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on that date, were you operating a motor vehicle in the city of Cadillac? And would you agree with me that that's in Wexford County? And prior to operating that motor vehicle, had you consumed alcohol? How much had you had to drink?
Approximately 2 drinks.
What were you drinking?
It was honey jack and Wiggins.
You said Honey Jack and Verner's.
On the paper for the, my capital services, it says 2 shots, but she misunderstood, when it said 2 drinks, I guess.
Okay, all right. And do you believe that those 2 drinks that you had impaired your ability to operate a motor vehicle? And did you have law enforcement interaction? Do counsel believe that the defendants provided a factual basis in which to accept the plea and the court rules have been complied with?
Yes, Your Honor.
Yes, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Mr. Barron, I find you guilty of operating while visibly impaired. Pursuant to the plea agreement, the operating while intoxicated will be dismissed. Counsel, I have a substance use assessment in my file that looks like it was received today. Ms. Lawrence, have you received that?
I have, Your Honor. I have not had a minute to read it quite yet.
And I'm in the same boat, so we'll take a quick break while we both do that.
All right, let's talk about that. This hearing carried a familiar rhythm we often see in traffic and misdemeanor cases: negotiation, plea entry, and then the real work of sorting out what's fair for sentencing. Judge Corey J. Wiggins handled it in his steady, measured way, patient when the details needed clarification, but firm in ensuring everything was placed cleanly on the record. He let the attorneys do their part, asked the necessary follow-up questions, and kept the proceedings moving without a hint of impatience. The defendant, Dylan Barron, presented himself with a mix of honesty and youthful nervousness. His plea to operating while visibly impaired was straightforward. He admitted to having about 2 drinks, clarified that a paperwork mix-up listed 2 shots instead, and acknowledged that the alcohol did impair his driving. There was no deflection or denial. If anything, his candor made him look more credible in the eyes of the court. He came across as sincere, almost casual in tone, but respectful. That balance matters. Judges don't need perfection, they need honesty, and Mr. Barron gave them that. On the attorney's side, both were professional and effective. Defense counsel, Mr. Hartel, had clearly worked through the plea deal with his client and ensured the record reflected accuracy. He emphasized that this was a one-off mistake, that his client had been cooperative, and that probation might not be necessary. Prosecutor Ms. Lawrence, for her part, pointed to the numbers, a BAC that raised legitimate public safety concerns, and argued probation would provide structure. It was a neat clash of perspectives, the defense leaning into rehabilitation through natural consequences, the prosecution emphasizing accountability through supervision. Neither appeared flustered. Both made their points cleanly. Judge Wiggins, though, steered toward a balanced middle ground. He recognized the BIC was high enough to be troubling, but weighed that against the defendant's age, employment, and clean assessment, indicating no substance use disorder. His solution: no probation, but mandatory programming, the alcohol highway safety class, and a victim impact panel with firm deadlines. That's a smart use of judicial discretion. It makes sure the defendant confronts the real-world consequences of impaired driving without overburdening probation services on someone unlikely to reoffend. He tacked on the standard fines and fees, a single day in jail with credit for time served, and then encouraged Mr. Barron not to let this be a setback. It wasn't leniency for its own sake. It was accountability tailored to fit the situation. The overall courtroom atmosphere was calm, respectful, and even lightly humorous in places. When the judge pressed about whether the 2 drinks might have contributed to hopping the curb, there was a wry undertone, an acknowledgement that while the numbers told one story, the defendant's own explanation had a touch of youthful optimism. These moments remind us that courtroom proceedings, even in serious contexts, don't have to be devoid of humanity. In the end, the case showed what can happen when a young defendant is candid, counsel is prepared, and the court applies the law with a mix of firmness and practicality. The outcome was neither harsh nor indulgent. It was structured to ensure lessons were learned and risks reduced. Mr. Barron left the courtroom with obligations he can realistically meet, a job he can keep, and hopefully a lesson that sticks long after the fines are paid. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.